So, hello everyone. As Professor said, title of my presentation is Changes in Children's Rights and Parental Responsibility in the Republic of Croatia over the last 10 years. So first, let's start with what is parental responsibility. Parental responsibility includes, first of all, it's a legal institute which embodies personal and human rights of parents, and today we can find it under terms such as parental care, for example, in Croatia, parental authority in Poland, and parental rights and responsibilities, actually obligations in Slovakia, and throughout history even as a parental power. It actually consists of duties, rights and responsibilities of child's parents for promoting and protecting child's personal and property rights and also child's well-being. What is important that this arises from a Family Act that regulates, from 2015, that regulates parental responsibility in Croatia, from the Article 91, paragraph 1. From the same article, from paragraph 2, it states that parents cannot renounce parental, now we will transfer to care, because in Croatia we use this term care, not responsibility. So parents cannot renounce it, and why is it so? Because it doesn't only consist of rights, but also duties and responsibilities. And the answer is very simple, because it can find its basis in the law of nature, because parents are the ones who brought this child to the world, and they are the ones who should also take care of this child under the condition they are capable of doing so. And in the last paragraph, it's important to say that they shall exercise parental care in line with child's developmental needs and capacities. And what is the content of the right to parental care? So it relates to, like we said, parental rights and duties, to protect and to promote child's personal rights, to health, to care, to protection and development, to education and upbringing, to determination of personal relationships, and of course the establishment of personal relationships and determination of the place of residence of the child. But it also includes rights and duties of parents to legally represent the child and child's personal and property interests, and also to manage child's property. But maintenance is not included, and the family law legislator has failed to include this, although it was during family law tradition part of the content of parental care. When it comes to who can exercise it, according to the Family Act from 2015, only child's parents can exercise parental care, but according to the Life Partnership Act from 2014, the third person is also involved, but we will discuss it later. So here I will talk about changes that occurred in Croatia in 2015 with the adoption of Family Act, and with the, in 2014 with the adoption of Life Partnership Act. So when it comes to Family Act, or how we call it in Croatia, Obiteljski zakon, its predecessor, Family Act from 2014, was suspended by a constitutional court due to lots of inconsistencies, due to unclearness of legal norms and also legal holes. And it was shortly after replaced with Family Act from 2015, which somehow managed to remedy major omissions. And now three things that I will talk about here that are very important, that are changes that occurred with this act in comparison to the Family Act from 2003. When it comes to the parental care in case of divorce, when it comes to the right of the child to express his or her own opinion in non-contentious proceedings, compulsory counseling and family mediation, and the right of the child to informed consent. So first, when it comes to parental care in a case of divorce, it is prescribed in the Article 105, paragraph 3, that one parent exercises parental care independently based on a court decision if parents did not reach joint parental care or an agreement during court proceedings. Also from the Article 105, paragraph 5, it arises that while passing a decision on the independent exercise of parental care, the court will determine whether the parent will represent the child in essential personal matters independently or with the consent of the other parent. So this means that if they didn't reach this joint parental care plan, then court can decide that only one of them will exercise parental care, and also that only one of them will represent the child when it comes to making decisions. And this is not in accordance, first of all, with Family Act that prescribes that they will exercise, with other provisions of Family Act that prescribe that they will exercise parental responsibility or parental care jointly, and also with UN Convention on the Rights of the Child, which also mentions that they will exercise parental care jointly. And case law here is going contra legem, so they don't respect these provisions. When it comes to the right of the child to express his or her opinion in non-contentious proceedings of compulsory counseling and family mediation, it is prescribed that in the proceedings of compulsory counseling, child may express his or her own opinion with the consent of his or her parents, and also in the proceedings of family mediation, where family mediator can allow the child to express his or her own opinion with the consent of his or her parents. But in the UN Convention on the Rights of the Child, in the Article 12, it is prescribed that state parties shall allow the child who is capable of forming his or her own views to express those views freely in any matter that is concerning the child, and then to those views a due weight shall be given in accordance with child's age and maturity. And UN Committee on the Rights of the Child, in its general comment number 12, explained that freely means that child shouldn't be under pressure when he or she is expressing his or her opinion, and also that he or she should decide whether he or she wants to express that opinion. Also, it should not be, he or she should not be manipulated or put as a subject to undue pressure. And child shall express his own opinion, his own views, and here we can see child won't express his or her own views if it's conditioned with the consent of his or her own parents. So here we see that Croatian family legislator wasn't influenced with this external factor, and should have been. When it comes to the right of the child to informed consent, it was introduced with this Family Act from 2015, where in the Article 88, it arises that child who has reached the age of 18 and who, according to the opinion of a medical doctor, disposes of sufficient information to make a decision on a concrete matter, and is mature enough to make a decision when it comes to preventive, diagnostic, or therapeutic procedure, can independently give consent to medical intervention or examination or test. In the Article 2, it says that if, according to the doctor assessment, there is a risk of severe consequences for child's health, then with child's consent, consent of parents is also needed. And in a case of a dispute between them, court will decide. For me, the problem is that from this first article, there is no difference, for example, when it comes to some procedure that is not very serious, such as removal of dental plaque, and, for example, something that is more serious, such as termination of pregnancy, which is in Croatia regulated with different legal act, which is then used as lex specialis, which prescribes that a girl at the age of 16 can give consent to termination of pregnancy, and if she's under the age of 16, then her parents or a legal guardian will give this consent. But what happens is that at the age of 16, if she's pregnant for more than 10 weeks, or if there is some risk that this termination of pregnancy will impair her health, then Commission of First Instance will decide about this, and her parents will only be informed. So in this legal act, we are just informing parents when it comes to termination of pregnancy, and they won't give any consent. And when it comes to Family Act, if there is some risk of severe consequences, then their consent is also needed. Now, when it comes to Life Partnership Act from 2014, First, I have to say that in 2013 there was a referendum in Croatia, and there was a question whether people agree that marriage shall be defined as a union, life union of a man and woman, and that this provision shall be introduced in the constitution. And 65% of people who voted were in favor of this, and 35 against this. So today it is incorporated. This provision we can find in the Constitution of the Republic of Croatia. So marriage is a life union of a woman and man from the Article 62, paragraph 2. And after that, as a response to this change, Life Partnership Act was adopted, and it introduced two important things. First is parental care. Now we are talking about this where third person is also involved in exercising of parental care together with child's parents. So it can either be on a basis of a court decision, where court can decide that a life partner of the child's parent has a right to exercise parental care with parents or instead of them, or where they can entrust exercising of parental care to the life partner temporarily, but in part or entirely. When it comes to partnership-based care, it's an institution that is content-wise similar to adoptio minus plena, so it's incomplete adoption, where these legal bonds with previous family are not terminated, especially when it comes to succession. This partnership-based care, so life partner of child's parent can become partner guardian in case if this child's parent life partner died, or if other parent of the child is unknown or is deprived of parental care due to child molestation. When it comes to the question of foster care and adoption of life partners in Croatia, so when it comes to foster care in 2020, there was a constitutional court's decision where constitutional court said that life partners have a legitimate right to expect that in a traditional type of foster care they are accommodated together already due to the fact that Life Partnership Act protects family unity of same-sex partners in the same way as it protects the marital union. And when it comes to adoption, same-sex couples or life partners still cannot adopt children in Croatia. What will happen in the next decade, I don't know. But they can, according to the decision of administrative court from 2021, they can go through a procedure to prove that they might be capable to become adoptive parents. And lastly, I would like to talk about this case, AK and L versus Croatia, which occurred in 2013. So before the adoption of Family Act from 2015, but due to this, Croatian legislator made some changes of the previous act, and they are transferred in this act from 2015. So the applicant child's mother was deprived of parental care, and child was adopted without her consent. And then a European Court of Human Rights stated that she was denied her legal right to request the return of parental care. And after that, changes of relevant provisions occurred, and now child's parent, that is child's biological parent deprived of parental care, shall be asked for consent when it comes to adoption, but that consent is not binding. So it's a change, but not some serious or huge change, I can say. And thank you for your kind attention.
Oh.